Joining us now to discuss the impact of this case is John Sherman. He is the litigation director and senior counsel at the Fair Election Center, and Andrew Lieb, a constitutional attorney. Thank you both so much for your time this morning. Andrew, the Supreme Court decided in 2019 that federal courts cannot hear gerrymandering cases. Now, this case looks whether state courts can be involved in those cases. So how much of an impact will that previous decision have on future state elections and future federal elections potentially?
Well, I think you have to look at them both together and what happens moving forward. And it really came down to what Justice Kagan said. There's never going to be checks and balances, assuming that this independent state legislator theory is adopted. Meaning the real question in this case is, in the Constitution, it uses the word legislature. Does legislature mean just the Congress in the state can make laws, or the entire state, meaning the governor, the courts? Is there a checks and balances, or can the legislature just choose how elections are done? That's going to be a radical shift from the way we understand things if this theory is adopted.
All right, so just it's a lot of legalese, and I like to boil things down a little bit here, John. The way I'm understanding the case is essentially there was this map that the good folks in North Carolina drew, the legislature, okay? And the court, state Supreme Court, struck it down, saying, no, you can't do that. So essentially this case centers on the idea that when it comes to federal election law, the balance of power should either fall to the courts or to the legislature itself, or some fairly complicated gray area in the middle. In layman's terms, explain why you think that is significant, because people are describing this, depending on what the justices do, as a fundamental change in how this country conducts its elections. What do you think, if anything, is at stake here?
Well, we have two systems of courts in the country, right? We have state courts and we have federal courts, and the U.S. Supreme Court is deciding here whether it's going to intervene in state court disputes, right? Interbranch disputes between the state courts and the state legislature. State legislature passes a map in North Carolina. State court strikes it down. There's no federal question there unless the U.S. Supreme Court adopts this fringe theory that says the U.S. Constitution gives state legislatures complete and unchecked power to pass any election law that they want with respect to federal elections, and the state court can't enforce the state constitution. That is a radical theory. It's never been adopted. You would never think that there's any role for the federal courts here, but the U.S. Supreme Court here is weighing whether to intervene. And the key thing, I think, for viewers to understand is this theory only pertains to federal elections, right? So the implication here for the future is, in other cases, not like this one, where there's just a congressional map, right? All election laws, like a voter ID law, absentee balloting law, they concern all elections, federal, state, and local. So that means if this theory were adopted, state courts striking down a particular election law, they'd be prevented from striking it down with respect to federal elections, but they'd be able to strike it down with respect to state and local elections. So that would lead to a split in any election law, and that spells chaos for administrators and voters.
Wow.
It's really interesting. And I think when we saw the oral arguments going on yesterday, there was an interesting breakdown between how the justices maybe appeared to be receiving this. Democratic nominated Justices Elena Kagan, Sonia Sotomayor, and Ketanji Brown Jackson disagreed with the theory. You had conservative justices Samuel Alito, Clarence Thomas, and Neil Gorsuch seemed to support the theory really in full force. But where it got really interesting was the Chief Justice, John Roberts, Justices Brett Kavanaugh and Amy Coney Barrett really seem to not be completely sold on this theory. So my question for you, Andrew, is even if the independent state legislature theory doesn't get majority support from the court, is it possible that the court still sides with North Carolina's GOP legislatures? Walk us through that.
So the court has a lot of latitude on how broad or how narrow they're going to make a decision, and they can pick it up on a lot of different grounds. So the core case, what you're asking, is in North Carolina. North Carolina's highest court shot down how they were drawing maps for 14 House seats, U.S. House seats. And so they could just reverse that simple, specific thing and say, hey, that was wrong. And what you're getting at is that we saw Kavanaugh and Roberts particularly looking for a middle ground. But I will point out to you that I think it's really telling that Kavanaugh went to the history of the language of the court. And he said in the history, the Constitution of the states was able to play a part in federal elections. And that tells us that he could really be the swing vote to say, hey, this theory is not going to be endorsed. This theory doesn't work because, after all, the real way that people need to understand this is that, do you want your elected officials, only your legislature, House, your Senate, your state to make decisions? Or should the governor be able to veto them? Should you be able to go to court? Should we allow legislatures to just run away and do whatever they want? Or is it the whole government of your state that dictates how your elections work, as we've historically, as Kavanaugh said, understood it?
And John, you used an interesting word a second ago that I want to come back to, and that was fringe. Why do you think this is being pushed, number one? And number two, how does this fit into the big 30,000-foot view of a country right now that is grappling with the issue of election integrity, false, unfounded claims about what happened in 2020, a country that is bitterly divided politically? This case falls in the middle of extraordinary context. How do you see this case fitting into that? And again, your use of the word fringe suggests to me that you think this is motivated by something perhaps untethered to political reality. Floor is yours.
Well, it's untethered to legal precedent, right? The Supreme Court has never in 233 years suggested that state legislatures can make any type of law untethered from state constitutions. They're given their power from state constitutions. State courts enforce those state constitutions. And the idea that a state legislature somehow has more power under the United States Constitution than it does under its own state constitution is ludicrous. But because politics is politics, and every actor in the space is looking for an edge, particularly in competitive states like North Carolina, they are seeking out new theories and ideas that have been kicking around for a while, right? This came up in Bush v. Gore in 2000 in a concurrence written by Justice Rehnquist. It was not to the full extent that the petitioner argued yesterday, but this idea has been kicking around on the margins for a while, and it is a good thing that the Supreme Court will finally resolve it, though we hope, as we argued in a brief we wrote on behalf of the League of Women Voters, that they should reject it. It would be profoundly destabilizing for election law and election administration around the country, and it would cause alternation in voting rules based on whether there's a federal race on the ballot. And that kind of alternation and splitting of voting rules can only sow distrust. And I think that goes to your point of this is not the moment to introduce some radical departure in American election law. That would just lead to undermining public trust in the stability and integrity of our elections.
And real quick, gentlemen, lightning round. Andrew, back to you. Do you think the Supreme Court ultimately buys into this theory when we get a decision middle of next year?
I think they're going to strike it down, not uphold the theory, but it's going to be 5-4. It's going to be a very close decision.
Wow, 5-4. John, how do you feel?
I don't like to make predictions, but I think you saw the justices struggling out loud for a limiting principle, and I think that's an encouraging sign. So we'll see.
Fascinating topic. Complicated, but fascinating and profoundly consequential if the theory got approval.
Potentially huge impacts there, widespread impacts,
Yes.
obviously.
With 2024 not far away, of course. John Sherman, Litigation Director and Senior Counsel at Fair Election Center. Andrew Lieb, Constitutional Attorney. Gentlemen, really enjoyed the conversation. Thank you both.
Thank you.